Hello, my name's Olurotimi Osha. Today is 19th of June 2026. Of course, today is June 18th, and of course, I give um, my commendation. I do give praise and my respects to um, Black Americans who did a lot in terms of establishing the rule of law, making sure that the rule of law, equality before the law, is available and observed and enshrined in our laws for everyone. Of course, know we had a nation of white men who were privileged, and then even white women were subservient despite what was enshrined in our Constitution. Now, African Americans would struggle and advocate and persevere over time to enshrine, codify equality in our laws. I'm an American citizen. I'm a naturalized American citizen. So today, what I really want to talk about is um, the McCarthy era clause that assists in terms of in terms of denaturalization, right? Um, there's a there's a so this government, right, the administration of number 45, 40, and 47 has emphasized that it's going to pursue denaturalization of people who pose a national security threat, and of course people who committed fraud during the naturalization process. So fraud, right? Um, Citizenship fraud has been the main form of denaturalization, right? So while you're becoming, and it's not a new thing, while you're becoming a citizen, um, you're taking an oath that you're not making willful misrepresentations, and you're supplying true information, and you're supposed to show candor, and you're taking an oath to the Constitution without reservation. Uh, And by the way, something also enshrined in the naturalization process is that there's no what's called ex post facto uh, denaturalization, right? So there's an ex post facto clause. Ex post facto means no retroactive law, right? You can't. So actions that occur that a naturalized citizen takes after becoming naturalized should not lead to their denaturalization. That's actually the law. That's the law. And however, the U.S. government had done this regardless. And this is something I also want to remind us that the government makes mistake, right? There are three branches of government, right? There's executive. They don't create laws. The president can make um, executive orders, but they're not binding. They're not binding like when Congress makes a law. There's administrative law, like within the executive arm of government, right? They've been delegated powers to make laws. But Congress provides them that authority. They still have to be able to. It has to be consistent with the Constitution, right? So it's Congress that makes laws with respect to the Constitution. So again, ex post facto clause, that means actions that a naturalized citizen takes, right, after he becomes naturalized and after they've sworn an oath, they've taken the oath. Those actions cannot lead to their denaturalization. It can't cause their citizenship to be revoked, right? And but sometimes the government makes a mistake. So there have been times that the government has passed laws attempting to revoke citizenship based on actions that a naturalized citizen takes after their oath, for instance. And this was common during the McCarthy era, right? Joseph McCarthy was a senator who during the Cold War, was really a fire. He was a rabble rouser, a firebrand brand who was haunting communists who were trying to subvert the U.S. government. And so there was a clause that was passed during that period, right, around 1952, that said a naturalized citizen, right, within 5 years, they have a 5 year window. If once they've taken the oath, they've become naturalized, they have a 5 year window in which if they join any terrorist organization, they weren't called terrorists back then, right? Back then, the concern was communist. If they joined any organization that advocates the overthrow, the subversion or overthrow of the US government, right, that poses a national security threat, then their citizenship can be revoked, right? So a 5 year window, but that clause has hardly been used, right? It's hardly ever been used. So people have not had to worry about it, right? It was, however, used in 2020 for a Pakistani who, Ayman Faris, he became naturalized. But after he became naturalized, within that 5 year window, he gave aid to Al Qaeda, right? He joined Al Qaeda, giving them aid to attempt to blow up the Brooklyn Bridge, right? So he was convicted and he was successfully denaturalized, right? This was in 2020. Now, he could have challenged it. So his lawyers could have challenged it, that, denaturalization for a crime, because so basically he was being denaturalized for a crime, right? Because the government has often bypassed that ex post facto clause, because the ex post facto clause is understood to apply to criminal cases. It's supposed to prevent a criminal penalty. It's saying that, well, citizenship cannot be revoked as a punishment for crime, right? But the government has typically tried to bypass that by claiming that, okay, denaturalization is not a criminal process, it's a civil process. And it was saying, what the government argued was that naturalization, citizenship is a privilege. That person who was being denaturalized, they obtained that citizenship privilege by fraud, right? They obtained the citizenship, the privilege in a way, in a process they should not have, right? They should not have, that had the official known that later on that they were intending to join Al Qaeda and to try and subvert the U.S. government, or then they would not have obtained that citizenship. Well, there's something flawed in that reasoning, and this is what I want to just quickly read. I want to read I found a copy of my own certificate of naturalization, and I'm going to just quickly read something from it. So it says, the secretary, having found that, that's me, Olurotimi Osha, secretary of, I think, Homeland Security. So it starts let me go all the way back to the top. So the certificate of naturalization identifies you and all of that. And then it goes, be it known that pursuant to an application filed with the Secretary of Homeland Security, blah, 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 the Secretary, having found that Olurotimi Osha, that's me, blah, 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 having complied in all respects with all of the applicable provisions of the naturalization laws of the United States, being entitled to be admitted to as a citizen of the United States, and having taken the oath of allegiance at a ceremony conducted by U.S. Citizenship and Immigration Services, right? Such person is admitted as a citizen of the United States of America, right? So you see, what I wanted to draw out was, it says being entitled. So citizenship is not a privilege. Once you've taken the oath, once you've gone through that process successfully to get an application, to get an opportunity, yes, it's a privilege. But once you've obtained it, you're entitled. It's an entitlement. And the law, again, I've said in Afroyim versus Ruskin. Ruskin was the Secretary of State, I think, who revoked his citizenship, who did refuse to give Ruskin. Ruskin was an Israeli, and he went to vote in Israel. There used to be this law, Nationality Act law, that said, well, if somebody voted in a foreign nation, then that showed that they had allegiance to another nation, and therefore their citizenship can be revoked. And that was what they did to Afroyim. But Afroyim went to court. He came back and he went to court. He had to come back on a visiting visa because his citizenship was revoked. So he came on a visiting visa. He filed an application, went to court. The first court denied it. He filed an appeal. They rejected it, sided with the government, and he went all the way to the Supreme Court. And then the Supreme Court sided with him and said no, that the Afroyim was right, because Afroyim was challenging an act made by Congress. It was Congress that created an act saying, I think that was the 1940 Nationality Act, saying that law was unconstitutional because it violates the 14th Amendment that guarantees citizenship, right? It says the naturalized and the natural-born citizens are equal, and there's no two-tier citizenship, right? And so Afroyim was saying that you can't revoke citizenship without the voluntary consent of the citizen, and the U.S. Supreme Court sided with him, and it established the law, and it overturned an earlier Supreme Court decision. That's Perez versus Burnell, a 1958 law. That was what established that. Well, that's where the courts established that the government can revoke citizenship for someone who goes to vote in another nation because without their consent, without the citizens' consent. And so Afroyim versus Rusk, 1958, overturned that. Now, in terms of the McCarthy era laws, now there was also what's called the Internal Security Act of 1950. The Internal Security Act of 1950 was a law during the McCarthy era that was targeting communists, communists who were advocating for the overthrow of the U.S. government and subversion of the U.S., using subversive activities. So the government decided that, well, that people who were naturalized citizens, they could revoke their citizenship, right? And like I said, these acts, though they're often challenged in the government. Now, the McCarthy era act that says that, well, that the government, that somebody who's been naturalized, they have a 5-year window. They're not safe. Whatever they say that's subversive, or if they go and join a terrorist organization, then their citizenship can be revoked. Like the guy Ayman Faris, right? That their citizenship can be revoked after they join a terrorist organization, within 5 years of their citizenship, right? Like they did to Ayman Faris in 2020 for joining Al Qaeda and trying to help them to blow up the Brooklyn Bridge. However, legal scholars, understand that they can, the act, such laws are unconstitutional. They contradict, they violate the guarantees of the 14th Amendment, right, which says citizens are equal, right, because they're equal, right, they're also equally entitled to the Bill of Rights, which includes the First Amendment. The First Amendment gives us freedom freedom of association, right? Freedom to join any organization, any association. So if you're giving a naturalized citizen a 5-year window, still watching them, saying, well, within 5 years of becoming a naturalized citizen, you can't join any organization you want to, like natural-born citizens can, right? Even though they've passed through the naturalization process and they're now entitled to their citizenship, then it discriminates against naturalized citizens and makes them second-class citizens, right? And that's obnoxious in U.S. law, right? It's heretical in U.S. law, right? In the U.S. Constitution. Remember, so sometimes the government will make a mistake and pass a bad law, and it takes activists, it takes savvy lawyers like the great legendary Thurgood Marshall before he became a justice on the U.S. Supreme Court, for instance, and something he remarkably did, and I want to just cite this, was Brown versus Board of Education in 1954, right? There was a law that said in Plessy versus Ferguson that established separate but equal, 1896, right? And this went on for over half a century, saying, well, the blacks and whites were equal if they so long as the government creates separate facilities, right, and makes those facilities equal. Brown versus Board, the NAACP, and Thurgood Marshall, the legendary Thurgood Marshall, had to prove that, look, these separate facilities were not equal, right? In fact, the facilities that black people had, that the government was spending on black people, were second class, right? And they were treated as second class citizens, and it was infringing on their constitutional rights, the equal protection of the laws that says they're equal citizens with white people. And that led to the overturning of Plessy versus Ferguson, and Brown versus Board of Education of 1954 became the law, saying separate is not equal, right? So it takes being a good citizen, and I did an earlier video saying Nigerians weren't good citizens of America because they don't know the law, and they're very willing to become second-class citizens and subservient people. In fact, that's what Jide Iware was trying to advocate to me, him and his wife, saying that no, I was a second-class citizen and that his children have more status as citizens than I am. That's heretical. That's not true, right? I'm going to do another video. I don't want to cut into this one, my line of thought in this one with regard to denaturalization, right? So that 5-year window, lawyers should be able to challenge it as being unconstitutional because it violates the First Amendment, right? And it violates the ex post facto clause, right? So ex post facto clause, the government has tried to get around it by claiming that, well, the ex post facto clause applies to punishment for a crime, right? And if they revoke somebody's citizenship because they joined an organization, they're not saying they're saying they're saying it's a denaturalization is a civil process. They can't get around that. They're just being specious, right? The crime, joining a terrorist organization, is in America, you can actually be prosecuted, right? We have laws that prevent that. We have the Alien and Seditions Act, right? The various espionage acts, Alien and Seditions Act of 1797, that allows the president to deport foreign-born people, foreigners, right, for engaging in subversive acts or things that threaten the U.S. government, right? So those are crimes. Those are criminal. They're criminal actions, right? Joining a terrorist organization is a criminal act in U.S. law. And so, and again, ex post facto clause says citizenship cannot be revoked as a punishment for a crime, right? You actually cannot do that. So that 5-year waiver is going to be challenged. Again, it's hardly used. It's hardly ever used. An instance that it was used again was the instance of Ayman Faris, the Pakistani, who joined Al Qaeda and tried to help them blow up the Brooklyn Bridge after he became a naturalized citizen. And the reason why it wasn't challenged is because he went back to Pakistan and he never pursued it. Like this guy, Afroyim, the Israeli who went all the way to the Supreme Court, He came to America on a visiting visa. He didn't give it up. He lost at a lower court. He appealed it. He lost there. He took it all the way to the Supreme Court, and the Supreme Court said, okay, you know what, this guy is right. That law that Congress created is actually wrong, right? It's wrong. It violates the constitutional rights and the entitlement of an American citizen. An American citizen citizenship can only be revoked with their voluntary consent, right? And an ex post actions that they take after they're citizens, cannot do not negate their citizenship. It can't infringe on their entitlement as citizens. My name's Olurotimi Osha. I want to stop this video here, and I will do a subsequent one and just expounding on the naturalization and denaturalization issues. And this does not constitute legal advice. Thank you.